Everyone may be seated. I would request Mr. Seacat to stand. Mr. Seacat, at this time, based on the verdicts rendered by the Kingman County jury of your peers, I find you guilty of murder in the first degree in violation of KSA 21-3401A, an off-grid person felony. I find you guilty of count 2, aggravated arson, in violation of KSA 21-3719A1, a severity level 3 person felony. And I find you guilty of 2 counts of aggravated endangering a child in violation of KSA 21-3608A1. That's a severity 9 person felony. I would like for counsel, if they have their calendars available, to...
One moment to get mine, Your Honor. I'm going to send, I unfortunately forgot it downstairs, but I do have something else we need to do on the record.
Okay.
Your Honor, at this time, the state serves upon the defendant its notice of intent to seek imposition of a hard 50 sentence pursuant to KSA 21-6620 subsection B. And if I may approach, I'll show that to the court. That notice has been signed by myself and the Attorney General.
Thank you. And have you provided a copy to counsel, or will you do so?
We will do so immediately as we walk out of the court, Your Honor.
All right. You can be seated. I want to go ahead and get a date set while we're here. And at the moment, I'm looking at Thursday, July 11th or Friday, July 12th, if you want to see what your calendar looks like, Mr. Falk, and other counsel.
I believe I'm actually out of state those 2 days, but I'm going to double check and tell you.
Your Honor, if I may. Your Honor, given the fact that the state is filing notice that they intend to present evidence of aggravating factors in this case, and we will need an opportunity to present mitigating factors, I would suggest 30 days out for sentencing is not going to be sufficient time for us to do that. I haven't even seen what their aggravating factors are that they're claiming at this time.
Okay. Rather go 60 days out, at least for a target date. I need to set some date today.
Yes, Your Honor.
Well, roughly 50 some days out, I have Monday, August 5th open.
My calendar is clear on that day, Your Honor. transcript of this case, I might prepare a motion for new trial, motion for judgment of acquittal. I would also ask, the statute prescribes that a motion for judgment of acquittal and motion for new trial are supposed to be filed within 7 and 10 days respectively of the verdict in a case. Given the volume of evidence in this case, I would request that I be given some additional time, preferably 10 days after the transcripts have been completed.
Any objection to that, Ms. Hanley?
I'll leave that up to the discretion of the court.
Okay. That seems reasonable. I don't have any idea, considering the length of this transcript and the heavy docket that I have in the next 60 days, when she'll get you that transcript. But I will, I think it's fair to give you 10 days after the receipt of the transcript to file your post-verdict motions.
Thank you, Your Honor.
Anything else?
One further matter, I'd ask that the defendant's bond be revoked at this time.
The defendant has never posted bond in this case, Your Honor. There's no bond to revoke at this point.
I understand he's never posted it, but he's been awarded a bond and that he could theoretically still post. We'd ask the court to revoke that and hold him.
Mr. Falk?
Your Honor, I leave that to the court's discretion.
Okay. Well, at this point in time, he's obviously a presumed imprisonment sentence. What the length of that imprisonment is remains to be seen. I previously had determined he was a flight risk. It's more of a flight risk today than he was before today. I'll revoke any potential bond. There is no bond in this case from this point forward. Ms. Hanley, I'll ask you to prepare the journal entry with regard to the jury trial, the bond, and if you would include Mr. Falk's 10 days to file his post-verdict motions after receipt of transcript.
I will do so, Your Honor.
Very good. The last thing I would say is that I'd previously entered orders in this matter prohibiting family members and others from commenting in public regarding this case. That order is now lifted. Anything else for the record?
No, Your Honor.
Not on that application, Your Honor.
We're in recess.
I'm going to give you those.